Tonight, a major shakeup in federal gun policy could be on the horizon. Lawmakers inside the United States Congress are advancing legislation that would eliminate the decades-old tax on firearm suppressors and short-barreled rifles, while legal challenges across multiple states aim to dismantle existing bans. If passed, the move could redefine how these firearms accessories are regulated nationwide. At the center of this development is proposed federal legislation that would remove the long-standing tax and registration requirements for firearm suppressors and short-barreled rifles under the National Firearms Act of 1934. For nearly a century, these items have been subject to stricter oversight than standard rifles or handguns. Anyone wanting to purchase one must currently complete a multi-step federal process that includes submitting fingerprints and photographs, passing an enhanced background check, registering the item with the federal government, and paying a $200 tax stamp. That tax, set in 1934, was intentionally high at the time, designed to discourage widespread ownership during an era of heightened concern over organized crime. The new proposal in the United States Congress would eliminate that tax requirement entirely. Depending on the final version of the legislation, it could also remove suppressors and short-barreled rifles from the specific regulatory category that currently triggers mandatory federal registration. In practical terms, that would mean these items would be treated much more like traditional firearms under federal law. Buyers would still go through the standard background check process required for purchasing a firearm from a licensed dealer, but they would no longer face the separate tax stamp system or the lengthy approval timeline that can stretch many months. Supporters argue that the change simply modernizes outdated law and reduces bureaucratic delays, while critics contend that eliminating the tax and registration framework could reduce oversight of devices they believe warrant tighter control. If enacted, the shift would mark one of the most significant changes to federal firearm regulation in decades, fundamentally altering how these specific items are bought, sold, and tracked nationwide. Suppressors and short-barreled rifles have been regulated under federal law for nearly a century due to historical concerns about crime, concealability, and public safety. A suppressor is a device attached to the muzzle of a firearm that reduces the noise and muzzle flash generated when a shot is fired. Despite common portrayals in movies, suppressors do not make guns silent. Instead, they lower the sound to safer levels, often comparable to a jackhammer or loud motorcycle. Short-barreled rifles, commonly referred to as SBRs, are rifles with barrels shorter than 16 inches. Their reduced length makes them more compact and easier to maneuver, but historically, lawmakers viewed that compactness as increasing the potential for concealment. Both items were included in the National Firearms Act of 1934, passed during an era marked by high-profile gang violence and organized crime. Lawmakers at the time sought to curb access to certain weapons they associated with criminal activity, including machine guns, sawed-off shotguns, suppressors, and short-barreled rifles. Rather than banning them outright, Congress imposed a steep tax and mandatory federal registration, effectively limiting widespread ownership through financial and administrative barriers. Today, oversight of these items is handled by the Bureau of Alcohol, Tobacco, Firearms, and Explosives. The agency reviews applications, conducts background checks, collects the $200 tax, and maintains the federal registry associated with approved items. The process can take several months due to detailed vetting requirements. Supporters of the current regulatory structure argue that this additional scrutiny helps ensure accountability and traceability. Critics counter that technological advances and modern background check systems make the extra layer redundant. Regardless of viewpoint, the regulatory framework reflects a policy approach rooted in early 20th century crime concerns that continues to shape firearm law today. The constitutional debate surrounding suppressors and short-barreled rifles centers on how the Second Amendment should be interpreted in light of recent court rulings. In the past few years, the Supreme Court of the United States has issued decisions emphasizing that modern firearm regulations must be consistent with the nation's historical tradition of gun laws. That framework has reshaped how lower courts evaluate challenges to long-standing restrictions, including those under the National Firearms Act of 1934. Supporters of removing the federal tax argue that suppressors and short-barreled rifles are commonly owned by law-abiding citizens and therefore fall within the Second Amendment's protections. They contend that suppressors, in particular, serve lawful purposes such as hearing protection and reducing noise pollution at shooting ranges or during hunting. From this perspective, the $200 tax, unchanged since 1934, was originally set at a level intended to be financially prohibitive and effectively restrict access. Although inflation has reduced its relative burden, advocates claim the tax still functions as an unnecessary barrier tied to an outdated policy goal. Opponents counter that historical precedent supports regulating weapons perceived as especially dangerous or unusual. They argue that the additional requirements, including registration and extended background checks, reflect a long-standing approach that courts have previously upheld. In their view, the existence of regulation since the 1930s itself demonstrates a tradition of oversight that may satisfy the historical test outlined by the Supreme Court. As lawsuits move through federal courts, judges must weigh whether suppressors and short-barreled rifles qualify as protected arms in common use or as categories that can still be subject to heightened regulation. The outcome of that analysis could influence not only tax policy but the broader boundaries of federal firearm authority. While Congress debates potential changes at the federal level, several states continue to enforce their own restrictions on suppressors and short-barreled rifles, creating a complex legal landscape. Even if the federal tax and registration requirements were eliminated, state laws would still govern whether these items are legal within their borders. Some states fully permit ownership in compliance with federal rules, while others maintain outright bans or additional layers of regulation. For example, states such as California prohibit civilian ownership of suppressors entirely, regardless of federal approval. In contrast, states like Texas allow suppressors and short-barreled rifles provided owners follow federal procedures. This patchwork system means that what is legal in one state can be a felony offense in another, underscoring the importance of understanding both federal and state law. Legal challenges are now emerging that argue some state-level bans may conflict with recent interpretations of the Second Amendment by the Supreme Court of the United States. Plaintiffs in these cases contend that if suppressors and short-barreled rifles are deemed protected arms under federal constitutional standards, blanket prohibitions could face heightened scrutiny in court. They argue that states must demonstrate a historical tradition of similar restrictions to justify modern bans. State officials defending the laws maintain that they retain authority to regulate firearms to protect public safety, even if federal standards change. They argue that local conditions and policy priorities differ across states, warranting different approaches. If federal law shifts and courts begin ruling on these challenges, the country could see a wave of litigation that tests the balance between state authority and constitutional protections. The ultimate outcome may determine whether current bans remain in place or are struck down. The political battle over eliminating the suppressor and short-barreled rifle tax highlights deep divisions within the United States Congress. Supporters of the proposal argue that the current system is outdated and unnecessarily burdens law-abiding gun owners. They emphasize that the $200 tax, originally designed in 1934 to be financially restrictive, no longer serves the same economic purpose but still creates delays and administrative hurdles. Some lawmakers, including figures such as John Cornyn, have previously backed efforts to ease suppressor regulations, often framing the issue around hearing protection for sports shooters and hunters, rather than public safety risks. On the other side, gun control advocates and many Democratic lawmakers argue that removing the tax and potentially the registration requirement would weaken oversight of devices they consider sensitive. They contend that suppressors, while legal in many states, reduce the audible signature of gunfire and could complicate law enforcement response in active shooting situations. Even if suppressors do not make firearms silent, critics argue that any reduction in sound may affect how quickly bystanders or officers detect and respond to gunshots. The legislative path forward is uncertain. A bill may pass one chamber but face resistance in the other, particularly if the Senate's procedural rules require a supermajority to advance controversial measures. Additionally, any proposal would need presidential approval or enough votes to override a veto. With election cycles, shifting party control, and competing legislative priorities, the timeline and likelihood of passage remain unclear. The debate ultimately reflects broader disagreements over firearm policy, regulatory authority, and how to balance constitutional rights with public safety concerns in a sharply divided political environment. If Congress ultimately eliminates the federal tax and related registration requirements for suppressors and short-barreled rifles, The immediate impact would be procedural and financial. Buyers would no longer need to pay the $200 tax stamp that has been required under the National Firearms Act since 1934. They would also likely avoid the months-long approval process currently administered by the Bureau of Alcohol, Tobacco, Firearms, and Explosives, which involves fingerprint submissions, photographs, and detailed application reviews. Instead, purchases could resemble standard firearm transactions conducted through federally licensed dealers, including the typical background check process. Such a change could significantly reduce wait times, which in some cases have stretched close to a year due to application backlogs. Manufacturers and retailers might see increased demand if the additional cost and delay barriers are removed. Supporters argue this would streamline the system without eliminating background checks, while critics contend that it would reduce a layer of accountability tied specifically to these regulated items. However, even if federal requirements are rolled back, state laws would remain in effect unless separately changed or overturned in court. In states where suppressors or short-barreled rifles are currently banned, those prohibitions would not automatically disappear. This could lead to an uneven national landscape where access varies widely depending on location. Legal challenges to state bans might intensify, particularly if courts interpret federal changes as reinforcing constitutional protections. Longer term, the policy shift could prompt broader debates about other items regulated under the National Firearms Act. Lawmakers and courts may face renewed questions about whether additional categories should remain subject to specialized taxation and registration, potentially opening the door to further reforms in federal firearm law. So, is this the beginning of the end for the 90-year-old suppressor tax? Or will the proposal stall amid political and legal challenges? As lawmakers deliberate and courts weigh in, the outcome could redefine the balance between federal authority, state bans, and Second Amendment protections across the country. We'll continue tracking this story as it develops. Stay informed.